Welcome to the Property Management Law Solutions Podcast. Your host, Attorney Tim Baldwin, will guide you in all things property management, law, markets, politics, and commentary. Your property is his priority. Here's your host, Attorney Tim Baldwin.
Welcome, everybody, to the Property Management Law Solutions Podcast. I am your host, Attorney Tim Baldwin. Thank you for joining me today. I'd like to talk about an important topic. It's not real exciting, probably to some people, but it's important nonetheless, and it relates to virtually every lease agreement a landlord may have with a tenant, and that is security deposits. Security deposits are one of those subjects that a lot of people misunderstand. They don't quite know what the laws are, or maybe what court decisions have been ruled on regarding how to handle security deposits. And in the nearly 20 years that I've been specializing in this area of law, I just come across so many different scenarios and situations where landlords simply don't get it right. And so while it's not a tremendously exciting topic, it's one that I think is really important to understand. And so today I want to just give you some highlights of what you need to be looking at and thinking about when you're dealing with a security deposit in the state of Florida. Now, keep in mind, this is not legal advice. This is me providing you with general information to help you gauge, where you are in regards to this. And of course, you need to have an attorney that can advise you and help you with things in your operations. So this is one of those important topics. Under Florida statutes 83.49, landlords have certain obligations regarding security deposits, such as how to give notice to the tenant of where their security deposit is being deposited, how to handle a claim, what to do whenever you're in an interest-bearing account or non-interest-bearing account, so on and so forth. So these procedures are within that statute 83.49, and failure to comply with that statute can result in your inability to use that deposit for any damages that the tenant may cause, or unpaid rent that they still owe you when they leave the tenancy. So look at 83.49 to start off with and understand what the requirements are. But in general, landlords have to leave the deposit in the bank account that they deposited in during the tenancy. Seems simple enough, but it has to be a Florida banking institution, okay? And that's defined in the statute itself. And I'll go ahead and get this out of the way, what I'm about to say. There is no such thing as forfeiture of a security deposit under Florida statute. Many times you'll see leases that say, if the tenant doesn't comply with the lease, they forfeit their deposit. That is not correct. That's not legal. And so if your lease agreement has that, you need to take it out because it needs to comport with 83.49. And that requires the landlord to actually make a claim on the deposit once the tenancy has ended and the tenant has vacated. So it has to be a written claim that specifies what you're claiming are damages, basically what the tenant owes you, and the specifics of that. It has to be certified mail to the tenant's last known address, and it has to provide the tenant with certain information, such as the tenant's right to submit an objection to the claim within 15 days of receipt of that claim. And it also has to provide the address of where the tenant is supposed to send the objection. So this is a form, basically, a form that comports with these requirements, and the landlord has to certify mail that claim to the tenant's last known address within 30 days of that vacate date. Now, if the landlord has no intention of making a claim at all, then the landlord has to actually return the deposit to the tenant with any interest, if any, if applicable, within 15 days of the tenant's vacating the premises. So that's the real basic requirement there. So there's no forfeiture. You have to make a written claim that specifies what the amounts are that you're claiming. Now, again, keep in mind, if you, as a landlord, do not send this certified mail, certified mail, within the 30-day period, you have waived your right to make a claim on the deposit. Now, you don't waive the right to be able to sue the tenant for unpaid monies that they owe, or even to use collection efforts to try to acquire that money if the tenant in fact owes it. But you waive the right to be able to use the deposit, okay? Now, on the flip side of this, if the tenant fails to object to your claim within the 15-day objection period, it simply means that the landlord can now use that money for the purposes that they're claiming. But again, that doesn't mean the tenant doesn't have a right to sue the landlord if they believe that the claim or the use of that money is unfounded or illegal. Now, again, when you look at the term security deposit, it's any monies being held by the landlord during the tenancy for purposes of securing the performance of the tenants. So whatever the tenant's obligations are, you're holding that money to ensure the tenant is going to comply with their obligations, whether that's caring for the property, paying rent, if there's fees or charges owed, for an example, a cleaning fee. If they have to pay a cleaning fee and they don't pay it, and you're holding that money for purposes of paying those unpaid monies, that is a deposit. Now, another one that you see a lot is a pet deposit. I've seen this quite often where landlords will require a deposit, but then say that, again, upon breach or upon some condition, the tenant forfeits that deposit. Well, if it's a deposit, if you're holding that money, it's a deposit. And so you have to treat all deposits as required under 83.49. So that's really, really important to understand. Now, one of the questions I get a lot is, well, how much can I charge for a deposit? Well, that depends. It depends on the tenant that you've placed in your property and various risks that that tenant may impose on you. Some tenants are higher risk than others. And so using your objective selection criteria, whether that's income amount, their past history as a tenant, any prior evictions, so on and so forth. So when you look at the totality of this person's history and the risk associated with them, you can charge a deposit accordingly. Traditionally, a deposit of 1 month's rent is very common. Okay, but that doesn't mean it has to be that. It could be more. But then you have other considerations such as, the marketability of the property you're trying to rent. Obviously, the higher the deposit, the less likely you may have to rent that property because, a lot of people can't afford to pay a lot of money up front. So you have the deposit, you have, application fees, you have background checks, you have, first month's rent being paid. You may even have more than 1 month's rent being paid. For example, if you have, prorated rent for the first month and then the second month paid in advance, some landlords may require the last month's rent to also be paid in advance. So a lot of tenants, when you add all that together, it can get quite expensive for a lot of tenants, even ones who have a pretty decent income. And so obviously, your other interest of placing tenants in that property as quickly as you can is also a consideration. Now, if this is a public housing authority lease, there's a different rule there. There's a rule or a statute that applies or regulation that applies that says you cannot require more than 1 month's rent or reasonable amount fixed by the public housing authority. So there is limits as it relates to PHA leases. But otherwise, if you're a private landlord, you use your risk factors. So there's not a statutory limitation in that regard. One thing to also keep in mind is fair housing laws. Okay, fair housing laws apply all the time. Okay, there's federal fair housing, there's state fair housing, there can probably even be local fair housing laws. Now, there's a lot of similarities in those, But the different jurisdictions may have some slight variations. But obviously, you should know probably that the federal law will preempt state law or local law when there's a contradiction or there's a disparity in the way they are worded. So the federal law is the standard, and then you have your state and local jurisdictions as well, as long as they don't contradict federal law. But fair housing can come into play when you're talking about classes of persons that are protected under fair housing. And so typically, and this is a big issue that really isn't really designed for this podcast, but there are two different types of discrimination. One is a direct or overt. The other is a constructive or maybe a disparate impact discrimination. And so sometimes, you can run into this issue if the deposit is being charged higher to a protected class than it is other people. For an example, this is just an example, and it's just one I'm pulling off the top of my head. If your policy ends up resulting in you charging a higher deposit for single women, for an example, or maybe a minority race, and then that is a consistent and sort of demonstrated effect of how you do business, that type of disparate impact can result in a claim of fair housing violation. Again, kind of a deep topic. It's not something that we can really delve into, and really is something that you should be discussing with your attorney on how does my policy fit within fair housing, and not to mention Victim Against Women Act, the Victim Against Women Act. That is another statute that is designed to protect people who are victims of domestic violence abuse. So an example of that, just to kind of get the little tip of the iceberg here, statistically, women are abused more than men in a domestic situation. And sometimes women who are in an abusive relationship may have a negative civil background, whether that may be, credit score or an eviction on their record. And those things are related to or because of their being a victim of domestic violence. And so then when you see that record, and then as a result, you're charging this, say it's a single woman, maybe she has children, a higher security deposit because you see this person as a higher risk, it could really and potentially be a violation of that act. Because again, that act is designed to protect people who are abused by their domestic partner or family member. When you see those situations, essentially, that person has to have the ability to show how it is that negative civil background was related or directly related to that person being a victim of domestic violence. Now, that statute, the Victim Against Women Act, doesn't apply to everybody because there's certain persons that are covered as a landlord under that act, and there's a list of them within that statute. In general, if you're a private landlord and you don't have any association with HUD, whether that's certain tax break loans or programs, subsidy programs, whatever. There's a list of them. Okay, there's 9 of them. If you don't fall within there, then you aren't bound by that statute. But again, there is a sort of crossover as it relates to fair housing. So you've got to be aware of that and understand that policies are good, and you need policies. They need to be objective. They need to be based in good business reasons. But even with those policies, there are situations where these statutes may require you to adjust your policy for that particular person. Now, I want to get back to what I referred to earlier when you're making a claim on the deposit. So you're sending a written notice to the tenant saying, "Hey, I'm making a claim on your deposit," and then it gets to the part where you need to list, okay, what those claims are. Again, as I alluded to before, those items have to be specific. There's a lot of court cases that have addressed this issue of specificity regarding a security deposit claim. So the general rule is that it has to be specific enough for the tenant to be able to understand not just the nature of the claim, but the degree, the location, the extent of that claim, so that they can make a reasonable, defense. If they think they have a defense to it, they need to be able to prepare for that, or the objection that they can possibly make as well. So for example, if you were to just to say, I'm claiming $500 for cleaning, okay, that may not be specific enough. You may need to state specifically cleaning floors in the living room due to excessive dirt, or scrubbing marks on the wall in the living room by the doorway, so on and so forth. Painting. If you just make a claim of, hey, we got to paint, that probably isn't specific enough. You need to specify, which rooms, which areas, even giving reasons why. For an example, holes in the wall, picture frame nails in the wall throughout the living room or the kitchen, having to patch and repair. Same goes for if you're claiming for unpaid rent. Don't just say unpaid rent, $1,500. Specify unpaid rent for June 2025, the amount. Same thing for fees. If there's fees, you want to actually itemize those fees. As I said earlier, a lot of times landlords will require tenants to pay cleaning fees. So if your lease says, there's a cleaning fee upon move out, you got to pay $300, and the tenant didn't pay it when they left. So you'd make a claim, cleaning fee per whatever the statute, whatever the lease provision may be, and the amount. It has to be specific enough to be able to give the tenant sufficient information so that they can either, prepare their defense, prepare the response, or objection. Another issue that I do see, and it's something that, quite frankly, is not as clear as you may think in Florida law, but the landlord has to deliver this 30-day, it's not a 30-day notice, but the notice within 30 days of the vacate date upon termination of the lease. There's two conditions there that have to be met for the landlord's deadline to be triggered under 83.49 subsection 3A. And that is the two conditions of the tenant vacated the premises, and the second condition is for termination of the lease. This word termination of the lease is actually, it's a legal term, okay? And there's conditions that have to be met for a lease to be terminated. Many times there has to be notice given, and also even with regard to the landlord's remedies under 83.595, there are instances where the landlord doesn't have to terminate the lease. Even if the tenant vacates, they can allow the tenancy to continue. It's called sit back and do nothing, and let rent accrue for the remaining term of the lease. So then the question becomes, well, if I exercise that remedy as a landlord, has the lease been terminated? And is my obligation under 83.49 triggered? Even though I did not accept the surrender, I did not take possession, and I'm going to continue to charge rent for the remaining term of the lease. And so there's this issue about termination of the lease. Now, I can tell you, just based on how courts have ruled on this and just playing this safely as possible, is to not wait for what you may consider to be termination of the lease. In other words, once the tenant vacates, with the intent of not living there anymore, I would use that as the trigger date for the security deposit claim. Because otherwise, if this becomes an issue and for whatever reason you send your claim after the 30 days has expired, then, the tenant's going to potentially raise that as the defense. And so why even have to deal with that defense when you can just use the vacate date itself as your trigger date and go from there? So anyway, that's one of those things, again, where it's kind of an interesting, maybe it's not that interesting, but it's something you should be aware of as it relates to this two-condition trigger event of tenant vacating and for termination of the lease. So there's another interesting topic, again, maybe not so interesting, but it's relevant to the whole security deposit scheme here. And that has to do with an unclaimed portion of the deposit. So if there's an unclaimed portion and a claimed portion, so let's just say the deposit is $2,000, you make a claim for $1,500, and so there's this $500 balance of unclaimed portion of the deposit. What are some best practices for landlords? And really, there's two ways of doing this. As a strict deadline standpoint, certainly we know that if there's an unclaimed portion of the deposit, when you have the intent to make a claim, which you are, and you've made a claim for a part of the deposit, is to provide that unclaimed portion of the deposit within the 30 days. So no later than the 30th day, you need to deliver that unclaimed portion back to the tenant. And then the other approach is that you would provide the unclaimed portion to the tenant, when you send your claim, when you mail your claim. So you have your claim, and then within the envelope, you would also have a check for return of the unclaimed portion of that. So those are the two types of scenarios. So, what's best practice? Well, kind of depends on your perspective. One reason you would want to go ahead and include the unclaimed portion of the deposit along with your claim is that it would alleviate a tenant essentially making an argument that, you should have given that money sooner. Okay. Well, and maybe you should have. If you don't have a claim for that remaining balance, and there's no potential of you having any further claim on the deposit, then returning the money along with the claim itself is a good approach. It's a safe approach. But there are situations where within the 30-day period, the landlord may discover other damages or monies owed that the landlord did not know about or was not aware of when they made their claim prior. So let's just say that the tenant moves out and the landlord goes in and inspects, the next day or the day after, and, they think they have what the damages are. They did an inspection. Here's the list of damages. And so they certify mail the claim, let's just say on the 10th day after the vacate date. So, you have 20 days thereafter under law that you could make a claim. And so why would you want to hold the balance of the deposit until the 30th day? Well, it's for this situation where, lo and behold, you inspect again or you're doing repairs or whatever, and it's worse than you thought. And so now you've got to make a supplement claim. Well, if you've already given the money back to the tenant, then you're without remedy of using the deposit at that point. So that's the reason, why it would be a good practice to hold on to the balance until the 30th day, because you can't hold it beyond that anyway if you don't make a claim on that portion of the deposit. So anyway, that's something to be aware of, and incorporating your policy decisions in regards to those types of scenarios. Now, what are the types of claims can you make? Really, it's any unpaid monies that the tenant owes you. That could be for back rent. It could be for unpaid fees. It could be for damages beyond normal wear and tear. It could be for cleaning or repairs or replacements that the lease agreement defines as a tenant obligation. So any monetary obligation the tenant has based on either, tort law, contract law, statute that the tenant has not paid you, those are considered to be, damages in short. And so you can make a claim for any of those items. Now, one thing to keep it in mind here, and this has to do with security deposits because of you're making a claim for monies owed, but it also gets into this world of, contract law, damages, and that sort of thing. And that has to do with, in the lease, requiring the tenant to pay certain fees versus having to pay for, say, actual damages or damages beyond normal wear and tear. Two of the most common of those are house cleaning fees and carpet cleaning fees. So when we talk about normal wear and tear, there's a lot of dispute about what's normal wear and tear. And obviously, it depends on the person's perspective. The landlord's going to have a perspective. The tenant's going to have a perspective. Chances are they probably don't line up perfectly. And so there can be disputes as to that. And then if there are and litigation ensues, you're leaving that question to a judge. Sort of the answer to that, or at least a part of the answer to that, is to define in the lease certain fees that the tenant owes, rather than relying on evidence of there being damages beyond normal wear and tear. So having a provision that talks about, house cleaning, it's going to be X amount, flat fee, or maybe it's X amount per square foot, Same thing with carpet cleaning. Those, the fees are much easier, obviously, to identify and to charge because it's just an agreed upon amount that the tenant would owe in the event some condition happens or you have to take some action on behalf of the tenant. So that's just something to keep in mind. Again, that has a lot to do with just leases, contract law, and how you want to operate your business. Obviously, the fees have to be reasonable, and importantly, using the fees that you're charging for what you're saying they're going to be used for. One of the things that has happened in some court cases have looked at this issue about when you're charging fees, but you're not using those fees for what you say you're using them for. That's another issue. That can actually get kind of a deep question in a sense, but you want to make sure that the fees are reasonable. And if you're charging a cleaning fee, use the fee for cleaning, okay? And this might be one of the last topics here, but this is a really, really important one. And it's one that you see litigated every now and then. And really, they can be some pretty big cases. Some of them can end up in class action, but that has to do with consumer protection laws. So one of the important things that landlords really need to know is that they cannot knowingly make false claims on a security deposit or even making, attemption of collection when they know the charges are unfounded. Okay. There are cases out there that talk about this, but when a landlord knowingly makes false claims or demands for money, the landlord is subjecting himself to lawsuits under consumer protection laws. Be really extra careful about that. And it's really also knowing the law. For example, the remedies that a landlord has under 83.595. Knowing what those remedies are and knowing what you can charge a tenant for, early termination. Because getting that wrong can really lead you to some pretty serious consequences, not the least of which is the attorney's fees on the tenant side, okay? So you need to be aware of that and always use solid evidence when you're making a claim. Don't make stuff up and use your lease agreement in support of what you're charging. I'll hit another topic here before I conclude. We're about at the 30-minute mark. I try to keep my podcast at about 30 minutes, but there's another issue that landlords have to be aware of when you're talking about making a claim on the deposit for damages, especially. And that has to do with assessing what damage amount is actually the tenant's responsibility versus the landlord's responsibility. So there could be situations where the landlord actually has some obligation as it relates to whatever the damage amount you're claiming is. And many times that has to do with the life expectancy of the damaged item. So carpet is a really good example of that. So carpet has a useful life expectancy. And so the landlord has an obligation, obviously, to discount what the value of the carpet is in relation to, how old it is, what kind of a condition it's in, when we're talking about the damages, like when that damages occurred. And so if the carpet has a 10-year life expectancy and the damage came when the carpet was, say, 8 years old, okay, so the landlord is obligated, not to charge the tenant for the depreciated value of that carpet and only for whatever was left on the balance of that life expectancy. So that's a really important topic to know about, because if you're going to charge the tenant an excessive amount and it's beyond the depreciated value or the fair market value of that item, and you make the claim for the full value, to say the full brand new value of that carpet, the tenant could, object and, possibly prevail on that issue. So you have to consider the item that was damaged, the depreciated value, and the factors that go into that, and make sure that you're not charging the tenant for more than what the tenant is actually responsible for. So, all right, I think that's the scope of what I wanted to discuss, but security deposits, again, are a misused or misunderstood area of law. And again, as we can sort of gather, there's issues here that landlords may not necessarily be aware of, that they need to know about. They need to know what the statute is. They need to know procedures on how to make the claim, what constitutes a legally sufficient notice to the tenant, the types of damages, the types of valuation that you're using for damages. And, some of these things are not always easily determined. Again, that's the reason that you need an attorney to help guide you through questions and issues and to help advise you on what's proper practice and procedure and what's proper protocol for you to be using in your operations so that you can avoid, incorrect claims, bad claims, claims that end up getting you into legal trouble or possible liability. So that's pretty much it. And of course, if you're a landlord, go to our website, pmlawsolutions.com. You can learn about me more there, as well as our law firm. We are a property management law firm. We represent landlords throughout the state of Florida. So check us out there. Social media links will be on the notes in this podcast, and contact us if you're a landlord, property manager, apartment manager, investor. We'd love to hear from you and talk to you about how we can help you further. But for now, thanks for listening, everybody, and we'll see you on the next podcast. Have a good one.